calling back the parties on mod number 3, Hudson versus Hudson, cause number 093-027-327.
Okay, so you had been given a copy of Exhibit B, which included the third page for the Mr. Zambrano's declaration. You have an opportunity to review that?
Yes, Your Honor.
Okay.
Clarification, am I presenting oral arguments regarding all three filings at the same time, or
I'm sorry, you,
oral arguments regarding all three filings, like the ex parte restraining order, the response to the adequate cause?
what I'm addressing today is the adequate cause. That's the request for adequate cause to be established. If adequate cause is established, then temporary orders can be entered. It would be temporary orders based off of the restraining orders that were requested on the ex parte restraining order. So it is kind of all tied together. The restraining orders would not be effective, or temporary orders would not be granted if adequate cause is not established.
Okay, thank
Okay.
you, Your Honor.
So you have all of the documents now, so you're gonna go ahead.
Yes, Your Honor. So proceeding,
Why don't we focus first on the basis for the adequate cause, because really that's what we're looking at.
yes, Your Honor. So the adequate cause, first of all, the mother does not meet the threshold for adequate cause. She admits that I've spoken with my children. There was no willful abandonment. I've tried to keep in contact with them. I had a family emergency come up in California. The mother found out through relatives where I was, and I wanted to see my children this summer. She denied me access to my children. So when I came back to Washington after helping my parents who were ill, and there's actually a ruling on that with regards to getting unemployment, that I was found in good cause for having to quit and then go down to California. I know it's not 100% relevant here, but just bringing that up. After I helped my parents who have severe chronic illness, they're like 70 years old and older. I came back to Washington the 29th of September. I requested to see my children with the mother. The mother started to beat me down with, well, I'll say she basically demanded that I give an address. At that time, I didn't have a residential address that I could call my own. Rather, I was staying with relatives, and I had a room that I was at as well. And I wasn't able to see my children then. And then I tried to see them additionally in Thanksgiving weekend, which was mine. The mother denied that as well.
So let me ask you this. You've informed the court that you plan to request a modification of your parenting plan.
Yes, Your
And
Honor.
you're planning to go forward on that. Why are you opposing adequate cause for this to go forward to trial if you're going to be requesting adequate cause anyway?
I'm opposing adequate cause filed by the mother because her arguments don't meet adequate cause. The threshold, she claims I have a mental illness. This was brought up pre-decree, and she signed off on the final decree stating that I'm okay, that my parental functions are fine. There hasn't been any significant or substantial changes.
But she's also now alleging abusive use of conflict since the time the petition or the parenting plan was entered.
The abusive use of conflict, I've made a couple calls. The Valley Medical Communications Center actually told me to call every time the parenting plan's violated to get it on record. These allegations of making these false reports, I see no records before me, and nothing that she's presented to me as exhibits that show that I claim that the children were being abused right then and there, like she claims I had put in. The other piece, this recent ER involvement where I brought my daughter to the ER, this was due to her statements to me that she had brought up these issues with her mother, and her mother did nothing about it for a month. And I brought her in to be checked out. It seems like she has not ever been brought into the doctor for regular checkups, so that shows that medical needs of the child are being neglected, a basic parenting function. So further, for entering my own adequate cause, eventually I'm going to do that. I want to add that 191 restrictions apply to the mother on the children, because the boyfriend who lives with the children in their home has either committed an assault or threatened to commit an assault.
Okay, we're not going to address your petition today.
Okay.
What you need to address is whether she's established adequate cause and whether the restraining order should remain in effect against you.
Okay, and so my restraining order, is that can be heard as well? I asked for one against her.
The only thing that's being addressed today are the adequate cause that she has filed, the request for temporary orders that she has filed, and then you had set over a motion for contempt, or the court had set over a motion for contempt regarding visitation.
Okay.
I believe those are the only issues before the court.
Your Honor, there was a restraining order that I got, an emergency one.
Right, that's the temporary orders that I'm talking about.
Okay, so am I permitted to speak about that one
Yes.
as well? Okay. Thank you, Your Honor. So the adequate cause threshold, I have argued it hasn't been met. That's all the reasons she has brought up. There hasn't been any substantial changes. And with regards to visiting my children, I just had a successful visitation. I'm making an offer of proof. I have pictures with me right now today of myself doing parenting functions with my children, which I can present if you
You
accept.
can't consider any new papers today,
Okay, Your Honor.
okay?
And there was no supervised visitation. I had overnights with them. Reunification was perfectly okay. I don't feel it's necessary to have reunification therapy.
When was that last visitation?
Last visitation began the day after Christmas.
Oh,
It should have been,
This year,
correct,
this last year,
2011.
2011, okay.
And it ended on the 2nd of January, 2012. I attempted to see my children on Christmas Day, but the mother counted a weekend that I didn't get to see them, the weekend prior to Christmas break, as if it were my weekend, and then said Christmas break began the next day. So that was another issue I didn't litigate on, but I felt it was kind of not in the best interest of the children to not be able to see me on Christmas Day. However, that happened, and then I got to see them the next day, and everything was successful. And I have evidence here that I can submit later. So why I feel the restraining order should continue against the mother or should be entered into? Is that something?
That whether the restraining order should continue against you.
Okay. The restraining order should not continue against me. It was lifted with regards to the parenting plan by Commissioners Judson and then also Stroud or Strobe.
That was the modification of the temporary ex parte order, correct?
Correct.
Okay.
Both of them felt it was completely unnecessary to restrict me from seeing my children, and they allowed me to see my children. And I did exercise visitation with my children, and I had attempted to exercise communication over the phone with my children, but the mother frustrated that process with conflict. And every time I've tried to be more involved in my children's life, the mother has frustrated that process with restricting access to medical records, to the school. So I'm trying the best I can to be able to support their medical and educational needs. When they're with me, I absolutely support that 100% of the time. I'm trying to also support it with the mother's help, as the parenting plan does state that she is to facilitate that process with communications and also with medical and dental information, or medical and educational information exchange. I did email the mother about the ER issue, what happened. This is in her inbox, an email that she uses regularly with me. She attempted to bring up as if I kept her in the dark about this. I did not. I've disclosed the reasons why I brought my daughter to a medical facility. And the report with regards to what she mentions, that I wrote a report, I did not. This report was actually filed for neglect by the staff psychologist on the Valley Medical Center staff.
Okay. So you had been gone for 8 months.
No, Your Honor.
How long had you been gone for?
I had left the end of March 2011 and returned August 2011. It was a short period of time.
So 6 months.
Approximately, Your Honor.
Okay. And during that time, the visitation under the agreed final parenting plan was not exercised, and now you currently have a permanent residence in state?
Yes, Your Honor.
Okay. And all of these other issues came up after the parenting plan was entered with CPS and the police and all of those issues, correct?
After the parenting plan, the issue
The
she's,
original parenting plan, the ones that she's talking about in her paperwork, the CPS calls, the law enforcement.
some of these issues, Your Honor, she's bringing up are pre-decree.
Okay, but which issues were post-decree?
Post-decree,
Post-parenting plan.
the issues with Thanksgiving timeframe, 2011,
Okay,
and Christmas timeframe, 2011. That's all I'm aware of. The CPS issue that happened, well, not CPS issue, but taking my daughter to the ER, that happened over
Okay.
my visitation Christmas schedule with my children.
okay. Anything else you want me to consider?
Let's see here.
Where are you currently living at now?
I live in Renton, actually the
Renton.
Renton Highlands.
You filed a pro se notice of appearance.
Yes, Your
I
Honor.
believe you had. I want to make sure that we have a correct address for you.
And on file, there should be where I can receive papers. I've put that in my declaration.
Is it the same address that you're living at, or is it a different address?
The address that I am living at currently was the same one I was living at prior to going and helping my parents.
Is it the same address to receive mail for your pro se notice of appearance?
Mailing actually goes to a P.O. box, but
Okay.
physical, like, process
So the
serving.
physical address is on the 204th Avenue?
Yes, Your Honor. And I've received certified mailings from the mother there.
Okay. Okay, reply?
Yes, all those reports that I did mention earlier were done after our original parenting plan was put into effect. And it seems that I'm not allowed to speak about this emergency room incident, but I didn't get the email until this morning that he actually brought them to the emergency room. And so I just feel that Mr. Hudson would not tell me where he was living. I did not get any information from anyone in his family of where he was living when he just disappeared in March. He didn't let me know. I found out from his family later on in September that he was living in California, but that he had just upped and disappeared from down there and moved back to Washington without giving them any notice. And
Can
so,
you tell me what concerns would you have, given the fact that the children have been visiting their father? What concerns would you have about ongoing visitation at this point?
at this point, I'm his erratic behavior, and I feel like he might be coaching them to say that we're abusive and trying to. I think it's just harmful to them, especially when he's having my daughter get a vaginal exam for no reason. And he makes false claims that this has been an ongoing problem, but yet in the report it said that it might be.
Objection, Your Honor.
What's the objection?
I'd like to make an offer of proof. I can bring all.
I'm not going to address new documents. What's your objection to the statement?
The objection is hearsay with regards to, she's stating my family said that I up and left.
Sustained. Go ahead.
Well, I didn't receive a phone call from his family saying that where he had moved to until after the fact. And so the problem is Mr. Hudson just ups and leaves without giving me any notification. I didn't even know that he was living in Renton before he moved to California. I still thought he was living in Snoqualmie. So I didn't even know he was living there. He'd always have me meet him at a Safeway grocery store.
Why do you believe that supervision is required, and why should he be the sole person to have to pay for it if you're requesting it?
First of all, Mr. Hudson hasn't been paying child support. He hasn't been up to date, and he's made one payment in the last 8 months. And it was
It's not a basis to restrict.
well, no, that's
contact
for why he should have to pay for the supervised visits. And I'm just afraid that he's gonna just up and leave again, and this time take the children.
Why would you believe he would try to take the children at this point?
He's been trying to do all these harmful things to me because he's angry at me.
You have a third party you could supervise?
Family first.
A
Oh.
layperson.
Not at this moment, exact
No
moment.
family members or friends that could supervise visitation?
Nope, I was forced to live in Washington State. He wouldn't let me live in Wisconsin with my family.
So nobody that you know of, the two of you may know that would be able to supervise?
Nope. I mean, I can ask somebody from church to do it.
Okay. Anything else you want me to consider?
No.
I have a question about this contempt request. Was there an actual motion in order for contempt, show cause for contempt? I didn't have one in the file. All I had was the order that said the contempt issues could be set over. The request regarding the makeup visitation was listed in one of your declarations. Was there a separate motion in order to show cause for contempt?
The order to show cause, Your Honor, was signed by Commissioner Bradburn Johnson, and that
Do you
was,
have a copy of that?
on me
I
right now.
have an order that said that the contempt issues could be set over to this date, but did you actually file a motion in order for show cause for contempt?
Yes, Your Honor.
Where is a copy of your motion in order to show cause for contempt?
The copy right now, I don't have with me. I can bring that back. I can print that out in the library.
Do you have a copy of the motion in order to show cause for contempt?
Let me double check, but I don't think so.
There's an affidavit of service, Your Honor, in which she received that. That's dated the,
But what I'm asking about is the actual motion filed. Was it this motion that you filed?
may I approach the stand? Your Honor, and look?
Is this the only motion that you filed?
No, Your Honor. I filed more. Can I see
Okay,
the top page?
I don't have that. What I have is the posting notice of appearance, the response to the petition, the respondent's notice of hearing for January 3rd, the declaration for your temporary orders in response, the motion for makeup residential time, and the motion to deny petition.
There should have been, Your Honor, a restraining order filed, or not restraining, I'm sorry, the contempt. I confirmed that with Rhonda. I'm not sure how it didn't, I know I dropped it in the box, the working papers box out there.
This separate motion in order to show cause for contempt?
Yes, Your Honor.
Okay. So that was done through the ex parte department for January 4th,
Yes.
where you had requested the restraining order against her as well.
Yes, Your Honor.
Okay. And did you file proof of service?
Yes, Your Honor.
Okay, I don't have the proof of service. Do you have a copy of your proof of service?
I can print that out again. There's a docket list online that's been freshly updated with the e-file proof of service from Ken, the process server. It shows up under my cause number as being filed a proof of service. I can go print it out as well. I can get that
You
copy.
received the order setting the show cause regarding contempt? Ms. Hudson,
Oh, I'm sorry, what?
did you receive the motion order show cause?
I'm not sure what I received one document about contempt of court, and that was it.
Okay, that was the one I was looking at.
Yeah, that's all I've
The
received.
contempt motion?
Yeah.
Okay. You wanna address that now?
Yeah, I feel that in order for me to feel safe and to know where my children are, I need to know where Mr. Hudson is taking my children. And so if he's gone for an extended amount of time, longer than a day, I need to know where my children are living. And his refusal to give me an address of where my children were staying is why I did not just hand over the children to him. That needs to be, it's very important that I know where they are.
Does he return the children after visitation?
No, I was supposed to go pick them up. So he could have been all the way to Florida for all I've known, driven all the way and say, hey, I'm living in Florida now after 2 days. There's no way I could have gone down there and gotten them. I need to know where they
Objection,
What's your objection, sir?
relevance,
I'm sorry?
relevance.
Well, it is relevant.
Okay,
She has
I
a
see.
valid concern here, so go ahead.
are. That's why I didn't just hand over the children. Plus, he didn't give me any sort of notice. He calls me at 9 p.m. at night. We've already made plans for that whole weekend. He didn't give me any sort of notice.
And the current parenting plan allows for visitation.
Right.
Okay. And you were aware of that parenting plan and the schedule allowed.
Right.
And under the parenting plan, he's to give you an address every time he moves, correct?
Correct.
And that's what you did not have.
That's right.
Okay. Where in the parenting plan can you tell me that you can suspend visitation for failure to provide address?
It's not in there.
So you decided that that was the appropriate action.
I felt it was safe for the children that if I knew where they were staying.
Okay.
I didn't feel safe when the last time he moved and didn't give us any notice and then just was gone. Well, I thought it was September till August. I had no idea where he was living at that time.
Okay.
I had assumptions, but he would never confirm anything.
Okay. Other than your concerns about his erratic behavior, is there anything else you want to consider regarding the restraints as to his contact with your children?
No, not at
Okay.
this time.
Okay, so reply to her response to your motion or show cause.
Yes, Your Honor, thank you. I had provided the address of where I am at to the mother. She's had this on file for months now. I'm not sure where she thinks that I'm just gonna take the children out of state. I personally have never done that. Personally,
When did
I've,
you first provide the address to her?
actually, post-decree, I had told her where I was staying, which was the children's grandmother.
But then you left,
Then I had left and
then you came back. So when
returned.
you came back, when did you give her the address of where you were staying?
I gave her the address, it was during the holidays. I had given her via email the
December
address of
1st.
where.
The Christmas holidays? you mean?
During the like Thanksgiving, Christmas timeframe, actually.
Okay, that's when you provided the address?
Yes, Your Honor.
Okay.
She demanded it, so I gave her the address. It was the night before I was trying to exercise visitation.
Okay.
And I'm not aware in the parenting plan where it allows her to preemptively deny me visitation. There is no risk. I have no history, no criminal history, no history of harming my children, no flight history. These are false allegations the mother has brought up pre-decree and trying to bring up again after the final decree. I've told her simply, I just want to see my children. I'd love to, be involved with them, and I want to be able to see them again. And it didn't seem to matter.
Do you have a third party that could supervise if necessary?
Do I? Yes, Your Honor.
Who would you have supervise?
It would be families first. If I was to go down that road, the families first.
For you to be supervised?
Oh, for me to be supervised?
Yes.
I would suggest families first.
You would have asked for the same place for you to be supervised?
It's different, actually.
Okay, so if the court required that your visitations be supervised, do you have someone that you could propose as a supervisor?
Yes.
Other than a professional party?
When you say professional, like with credentials and everything? Or along those
Yes,
lines,
a
yeah?
family member, a friend, a church member, or someone from the community?
Yes, Your Honor.
Who would you propose?
I don't have a specific name, but there's an organization called Family First. They're certified out of Seattle, South Seattle.
Are they someone that you have to pay?
Yes.
And you would feel comfortable with them supervising if necessary?
Yes, Your Honor.
That's the same one you proposed?
Yeah.
Okay.
My understanding, Your Honor, is she was wanting one in Federal Way. Is
And you were asking for the one in Seattle?
correct.
Anything else?
So what am, at this point, what am I speaking about, Your Honor?
The contempt issue.
Contempt issue. So the only other thing I can add to that is it was willful. She had sent a follow-up email, which I have with me today, that stated that she was not going to follow the parenting plan because I was not following the parenting plan.
Mhm. Okay. Well, there are multiple concerns noted by the court regarding the first issue I'm going to address is the contempt action. Both emails go back and forth from both parties talking about the concerns regarding the visitation schedule. One email or text that's sent says, drop all the child support issues and then I'll go ahead and agree to this other thing about the visitation. Hers says, I'm not going to follow it because you're not following it. And when it comes down to it, it looks like there have been mutual bad acts on both parties, and therefore the contempt is coming forward before the court from someone who has not been following the plan either. So the request for contempt is denied. However, the concern that I have is the ongoing issues regarding how this visitation is going to take place, given the conflict between the parties. The visitation needs to be followed as it was. The concerns noted by the mother at this time regarding the flight risk is not grounded, I believe. It does not appear to be supported by the evidence presented to the court. However, there is sufficient concern about the ongoing litigation that's occurring between the parties that both parties should be restrained from removing the children from the state of Washington, absent a court order. Mr. Hudson, you bring a request today stating that the court should not grant adequate cause because she has not met her burden of proof, yet you come here today stating firsthand that you wanted the court to consider your request for adequate cause even though your petition hasn't been filed and it was not properly before the court. One of the suggestions by the respondent mother is that you are using abusive use of conflict. Since the day the final parenting plan has been entered, there have been concerns about it. While this is disputed by you, I do have to take into consideration all of the ongoing issues that have occurred. The reports, which apparently were deemed false, reports to CPS, the ongoing concerns regarding taking the children for evaluations. And these are quite intrusive evaluations. I'd be concerned if you're continuing to do this. The child is in the primary care of the mother. The mother should be making sure that regular medical appointments are being kept, and all of these issues are addressed to the primary physician. And you certainly should let the father know if there's a medical exam scheduled. While the issue is in dispute about the abusive use of conflict, the concerns noted are sufficient enough to proceed to trial so the trial court judge could make the determination of whether there has been abusive use of conflict. The change in the address of the father for such a significant period of time also is an issue that the court has to look at because there has been an extended period. While it hasn't amounted to the full year that was alleged initially in the petition, it is a substantial amount of time of absence that the court should be addressing in terms of whether there need to be modifications to the parenting plan at this point. And I do believe that adequate cause exists. You certainly can file a cross petition if you wish to, which you've notified the court you plan to do anyway. You certainly could proceed and maintain the same trial date as long as your petition is approved as well. So adequate cause will be granted at this time. You still need to follow your own schedule if you wish to do that, and I would encourage you to make sure the trial dates are combined so that you're not being set for two separate trial dates. With respect to the temporary restraints, both parties are restrained from disturbing the peace of the other party. That should include the concerned and the children. That would include refraining from taking the children into for physical exams that are not the regularly scheduled exams. That would include, while it certainly, I don't want to prohibit necessarily either parent from phoning in concerns to law enforcement or CPS. You should be aware that false claims to CPS can result in criminal charges. Both parties should be aware of that. False use or inappropriate use of 911 could carry some sanctions as well, so you need to be aware of that. But more importantly, it places your children in a situation where they are repeatedly being exposed and evaluated, and it's very intrusive, especially for children this age to be repeatedly subjected to sexual abuse exams and physical abuse exams if it's not substantiated. So there's a real concern about that. If you have concerns, parties should be scheduling the appointments together and trying to set those up, and I know it's going to be almost impossible to do so, but you need to think of the children first. The request for the supervised visits, unless you're gonna help pay for them, I am not gonna require supervised visits to be professionally scheduled. If you want them to be professionally monitored, you will have to provide the amount based on the child support proportional rate. Otherwise, the visit should proceed under the current schedule, provided the father has given a valid address where the children will be, and the children are returned to school on time, and that they are returned on time from their visitation. If there are missed visitations, they will not be made up unless there is 24 hours in advance written notice about a rescheduling need. If you leave the state, or for any reason you do not, that is not in writing and notice given, the visits will not be made up.
May I take a vacation if I give him like a 30-day notice? As long as I have a schedule when I'll be
Written
back.
notice, I think as long as it follows the parenting plan requirements, that's fine. I think it addressed vacation in the parenting plan.
Okay.
So as long as you follow that request for the parenting
So
plan.
if I agree to the pay for half of the, or whatever my schedule is for the supervised visits, then it's granted.
If you're requesting that their visits currently are, let me see, what's the parenting plan?
Your Honor, can I say something?
Hold on,
Okay.
please.
Yes, Your Honor.
Go back to the parenting plan. That was the final order. How old are the currently? How old are they?
4 and 7.
4 and 7, and the current schedule, and he is not in the current school district, is that correct?
He's going to preschool right now.
No, the father is not in the current school district.
No, he's not.
So it's every other weekend from 6 p.m. Friday to 6 p.m. on Sunday. So you would not have professional supervisors available for that type of visitation.
Okay.
I don't believe you've met a burden to restrict visitation at this point. While it is concerning he hasn't had visitation for a long period of time, there were also no specific concerns regarding the children's risk of harm at this point.
Okay.
We would like you to look into perhaps a counseling
I've already set that up
for
for my
the
children. I have.
Okay, please make sure you get that done. And I think what I'm gonna do is refer this on to Family Court Services to do a parenting evaluation to determine whether there need to be restrictions regarding the either parent's time with the children, and then that would be available for trial.
Okay, great.
The current restrictions would be that the father must provide the actual address where he will be residing so that the mother can pick up the children. So the way it works is that you go to pick them up and you go to pick them up from his place, or how does it
No,
work?
he refuses to let me come over there. He makes me meet him at a grocery store.
Your Honor, she has in the past complained about the distance, so the grocery store is actually 15 minutes
Where
closer.
are you meeting now? Where are you gonna meet now?
I'd like to pick them up from the house so I can make sure that's where they're staying.
And also in the past, she has started to argue during
You have
exchanges.
third parties that can go with you.
Yes.
If this is gonna become an argument, then there's an issue. If you have concerns about the housing, you can request a welfare check or whatever, but I don't want this to turn into.
The biggest issue is he's always late to drop them off. And so I drive all the way to Renton, wait at a grocery store a few minutes from his house, and he's 15 to 20 to
I
30
disagree
minutes.
with
We
that
can
statement.
resolve that issue. It will be pretty easy to resolve. So if you're gonna be at this place, then you have to be there on time. Any questions about that?
No, Your Honor, the
So where are
same.
you gonna be meeting?
So for pickup, I will meet at her home, as I've been doing to pick up the children. And then for her pickup, I've scheduled it already where we've been coming to Safeway parking lot. That's that's been happening.
You can go to her home, but she can't go to yours.
If she wants to come to the home, that's fine.
Okay, do you wanna go to the home?
Yeah,
Okay,
because then I can just
pickup
be there
will
on
be
time, not have to wait.
Pick up and drop off at the homes. Have the children exit the home to the car,
Yes, that's fine.
okay?
Yes.
There's no need to go up. They're old enough to walk, they can walk
Mhm.
to the car.
That's what I do when they come.
You can stand at the doorway and send the kids to the car. That simple. There's no reason for you two to have a conflict.
Yes, Your Honor.
Okay, so that will be the temporary requirements.
Can I
Any
bring-
other issue?
The issue, when she's come to the home in the past, she'll honk the horn erratically. She'll sometimes yell from the street. So I just want to make sure that doesn't
You know
happen.
the time that she's supposed to be there, correct?
Yes, Your Honor.
Okay, she's gonna show up at your house by 6 p.m. At 6 o'clock, you send the children out.
Yes, Your Honor.
If there are delays, document them and
Okay.
bring it to court if you have to, but hopefully the parties are gonna start accessing the mediation that is required, which is the disputes between the parties other than child support disputes shall be submitted to mediation. So they'll go to the mediator if you have disputes regarding the visitation schedule of pickup and drop off. Okay?
Yes, Your Honor.
Any other issue? Okay, so we're gonna have to have a temporary order prepared. It's gonna be a bit, cause I have some other issues to take care of, and then, do you have proposed orders? Bring proposed orders. I'm gonna have you, I don't know how late the family court facilitators are open. You don't have proposed orders?
Did I didn't put them in there? I think I put them in there.
These were your originals?
I-
What you need to do is go get your, I think I have originals.
I'm sorry.
You're gonna have to take a seat then, and I'll have to, address this.